that we can now apply the principle of res ipsa loquitur, that if there is no complainant and we see that the decision is really wrong, misapprehended the facts, misapplied the law, favor a party, a motion for inhibition must file against him, he did not inhibit. I think even if there is no complainant, we can do that because we have been also doing in the past. In fact, in one of the cases that I wrote now, I said that this judge should be investigated on the principle of surreptitio loquitur. I have been advocating that principle, Your Honor, because you cannot wait a party to file a complaint. In the meantime, that you are waiting for a complaint, tuloy-tuloy pa rin nag-misbehave ng judge, like one judge in Panikitalak, deciding cases of annulment, he was under suspension, Your Honor. That's number one. But insofar as the lawyers are concerned, Your Honor, that's really a problem because we do not have the resources to monitor all the performance of all lawyers unless of course, if the IBP will actively participate in policing their own ranks.
U.S. Justice Felix Frankfurter refers to the Supreme Court as an institution where every justice is his own sovereign. They are independent, just like here in the Philippine Supreme Court. How can you effectively, promptly initiate reform if you have to go to the en banc and secure the approval of the majority? In all instances.
As what they've been doing in the en banc sessions, Your Honor. If you have your opinion, then present your opinion, then defend your opinion. If they do not believe on your opinion, like because of the practice of democracy, then let's vote. If your opinion is not accepted, the majority, then your opinion becomes dissenting opinion, and then you voice out your opinion.
The reforms that you will initiate might be stymied or impeded only because you have to ensure collegiality within the court.
Yeah,
now, the presence of the 15 members of the bank, they are concentrated mainly on decision-making, the way I look at it, but they do not monitor the performance of the judiciary. Is it not about time that there should be a performance evaluation of all judges? Because at any rate, the Constitution speaks of judges shall continue in office during good behavior, meaning to say they're not only intellectually competent, emotionally competent, mentally competent, and efficient. So the point is, why not tap the Philippine Judicial Academy and the JBC to conduct an annual performance evaluation of judges so that the PhilJA can take care of the skills and the attitude of judges, their technical knowledge of the law, and the JBC can handle the mental competency of judges. That is something which
that's well taken, Your Honor. In fact, one of my programs, if given the chance to serve as this, is to monitor the performance of judges. My experience in the Supreme Court is this, Your Honor. Probably, with due respect to my colleagues, probably I'm the most traveled justice of the Supreme Court now, because I've been traveling for the past 4 years, lecturing on small claims, developing skills of judges. And I see when the judges see me, Your Honor, their morale is high. And I communicate with them. I know their problem. And I bring the court administrator and the deputy court administrator, and then I ask them to answer their queries. And there was a suggestion, I suggested then, Your Honor, that why should we, the justices of the Supreme Court, be divided into several groups? And let us see, you will be assigned places to oversee or supervise, so that we can see also how the judges are performing, and also to boost their morale, because it's different if a member of the court is with them most of the time, Your Honor.
Talking about your foreign travel, you've been to many places attending seminars, either as a participant to enhance your judicial training and experience, and also lecturing in foreign countries. If appointed Chief Justice, will you still be doing the same thing and be an absentee Chief Justice?
That's a good question, Your Honor. Modesty aside, Your Honor, all these years, I have not, all these years, there are times that I did not make use of my wellness, Your Honor, because people say I'm a workaholic. But if given the chance to become a Chief Justice, Your Honor, I will still see to it that I will have time to go around the Philippines and see the judges, but no longer on regular basis, of course, Your Honor, because we have not to concern. We will now have more administrative work than judicial work.
Talking about international convention seminars, making them available to judges, would you be willing to rationalize it? Should participation in foreign international conventions be limited to judges who are outstanding or to judges? Because if judges are outstanding, then they're already excellent. They don't need further training. So probably you should farm it out and give it to judges who have lesser training. Would you agree with that?
That was just a good suggestion, Your Honor, but in my case, my members of my committee have been helping me in all these endeavors, in the small claims, in the continuous trial, environmental, and so on, Your Honor. I always make it a point to include them in training programs abroad.
About courthouses, halls of justice, is it about time that we should ask the LGUs to shoulder the expense of constructing halls of justice? Because at any rate, the judiciary is serving the constituents and the LGUs.
That's, I hope you will agree with me, Your Honor. It's this. Remember when we decided the case of DAP? If the DILG or the local government will spend for the building of the Supreme Court, there might be a question of cross-border transfer of funds, Your Honor. It is put up by a executive government, and it is used by a different branch of government. A question may be raised that might be a cross-border transfer of funds, which we decided in that case of DAP is not allowed by the Constitution. Number two, Your Honor, my suggestion is that the Supreme Court should now form its own bidding committee. Kasi dito sa Supreme Court, ad hoc eh. When you speak of ad hoc, we get the chief of the legal, chief of the FMBO, and then they become members of an ad hoc committee bidding. Why not put up a committee for that purpose? Kaya mga infrastructure projects minsan, nadidelay po eh. Yun ang sasuggest ko, put up an office. These chiefs of other offices, I'm not saying that they're honest. Of course, they are very honest. No? Unquestionable integrity yan eh. But what do you expect from them? They have also a lot of work to do. In the OCA, Raul Villanueva, Deputy Court Administrator, taking care of all the courts outside of Metro Manila and Luzon, being a member of the bidding committee. The chief of the attorney's office, member of the bidding, all ad hoc eh. So, but why not put up a bidding committee for that purpose, so that we can also help the needs of the JBC?
Now let me go to some high-profile cases you decided. You decided the case of Estipona, where the court struck down the provision in the drugs law which prohibits plea bargaining in drug cases. And the court, and I was a part of it, I concurred in your ponencia, that particular provision prohibiting plea bargaining in drug cases is unconstitutional. But there is perception from some sectors in government that it sort of put a damper on the drug campaign cases because it stymied the effectivity of their drug operation.
Yeah, I hope you will allow me a longer answer, Your Honor. It's like this. We came up with a framework in plea bargaining after consultation with the Department of Justice through the Prosecutor General, the judges, the PDEA, the policemen. All of these people were consulted on this framework, the possibility, what should be the subject matter of plea bargaining. The problem in our second level courts, Your Honor, is that there are 100,000, the data shows that there are 100,000 drug cases filed before the court. And 70% of these drug cases are cases involving Section 5, which is the sale or transport of delivery of dangerous drugs.